So there is a requirement for registration of your building if it is a high-risk building, whether that's a new build, okay, or whether it's a legacy building. You have to register it with the building safety regulator. The building safety regulator has to issue you with a building assessment certificate. And what that does is, I guess it does two things. It basically says that your building complies with the regulations, but it also says your building's safe to be occupied. And that's the two things that they're trying to establish for you. But the things I want you to make you aware of is that complaint mechanism. The fact that residents can escalate their safety concerns directly to the building safety regulator, and they can bypass anyone that's got responsibility or ownership for the building and go straight to the building safety regulator. And the building safety regulator is able to come and start to investigate that complaint. So please do be aware of that. And the other thing to be aware of is that the former Secretary of State, Mr. Gove, you remember him? he put in some protections to limit the amount of money that can be charged to residents for previous defects. And I think what Mr. Gove was concerned about was, if there has been a builder that's come in and they've done defective work, the first port of call must be to go back to that builder and get them to put the work right. And so the cost of that work should not land with the occupiers of that building. They've done nothing wrong. I think that's where he was coming from on that front. Also, there are various safety schemes and cladding safety schemes that are in existence that where you were able to get public funded money to do any remediation work to bring your building up to scratch. So I think efforts have been made to limit the amount of money that's placed on residents. But without a doubt, you're not going to be able to protect residents from everything. There's certain things, and I'm going to suggest to you that this legislation, places costs that have to be passed back on to residents. So yes, there's limitations and leaseholder protections for past defects, but this new legislation, I'm going to suggest to you, places additional burdens, cost burdens onto the residents, and it has to go to the residents, the occupiers of this building. Now let's just talk about some of the powers that the building safety regulator has, because I think that's quite important for you to understand as well. So the first thing that the building safety regulator will do, and maybe one or two of you have seen this already, he'll issue you with a notice, and the notice will usually say something like, your building is identified as a high risk building, I require you to submit to me your building safety case report and mandatory occurrence reporting procedure, change control procedures, etc. And I'm going to give you 28 days to produce that information. So you'll say something like that. I don't know. So a few people will have got that already. So do be aware. They have the ability to enter your premises. Now that's interesting, because what they can do is they can come into your premises and they can seize any evidence of you not managing your building properly. And they can require you to provide them with evidence. And I guess if you obstruct them from doing so, they could bring charges against you for doing that as well, because they have a legal right to require information and to seize evidence. They're able to prosecute in the court of law. And this is an interesting thing as well. I mean, it's no different to what the Health and Safety Executive do, and I don't know if I said, I probably didn't say, but the Building Safety Regulator sits within the Health and Safety Executive, and they use the same sorts of mechanisms. So when it comes to charging for their costs, all they do is they just pass the bill back to you. So if they are doing an investigation into you and your building, how your building's managed, all they do is pass all of that investigatory cost back to you. Okay, and you will be required to pay it. They have the ability to insist on more frequent inspections. If they think that the building isn't being managed as it should, then you say, look, I want to go in quarterly now because I'm concerned that you're not running this building as you should. Okay, so do be aware of these and other sanctions that they have. Now, I'm going to pause there, if I may. I'm going to just ask if there are any burning questions that people have. Do you want to, does anyone want to ask any burning questions? You can take yourself off mute for a minute or two. Any
Basil,
burning
it's
questions?
Alison. There was a question in the chat from Ivan.
Yeah.
Ivan asks if a building is less than 11 meters, how often do safety/fire risk inspections need to be done?
I would say every 3 years, and that's typically what the law, the 2005 legislation, does not specify a frequency, but typically people seem to be going for every 3 years. You can do it more frequently. Be careful about doing less frequently because I think 3 years is about the limit. Okay, does that help, Ivan? You can come off mute if you want, Ivan. Okay, don't worry. Oh
Said
yeah, I've got,
yes.
yeah, he said yes. Okay. And any other burning questions before I continue? Well, yeah, I mean, is that because I'm doing such a fantastic job at explaining everything? Is that what it is? All right, maybe not.
Yes, Basil, you're doing a fantastic job. Yes.
Thank you very much. I like it when people humor me.